Hello folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. So today again we are continuing with the winding up of the companies, right? And the basic chapter under consideration or the basic topic under consideration for today's lecture would be the procedure of the members voluntary winding up, right? So far we have had already a couple of lectures on winding up, and over there we have already discussed the entire procedure of your compulsory winding up. We have started with the voluntary winding up, seen the declaration of solvency and other things. So if anybody of you who is watching this video for the first time, please refer back to the previous videos for those kind of topics, right? The topics that are covered in those categories. Because now we have already we are in the middle of the members voluntary winding up, and along with it we are also discussing the creditors voluntary winding up, and next we will be going on to discuss the winding up by supervision of the court. And then the basic procedures of the entire winding up will come to an end. And you know that the last topic that we are discussing, the winding up by supervision of the court, will be a very small topic, right? I think it will be done in one single lecture. And then you have some terminologies to discuss, contributories, creditors and stuff, defunct company and all. And then we will be done with the entire chapter. So that will be the flow. So there are some more topics, some more sections remaining. So I'm just giving you an overview so that you are prepared. And let's hope in a couple of more lectures we'll be completing this entire chapter, right? So those who have not been to this, or for them who are viewing this lecture for the first time, please refer back to the previous lectures because we are in continuation. Specifically this lecture you will have to go through the immediate preceding lecture, right? Because we have completed the topic of the procedure of the voluntary winding up by the member. We were half the way when we were short of time. Right, and so in this class we will be covering the other half. So unless and until you know the first half, it will be difficult for you to understand the second half. Right, so just a request, please refer back to that video and then come back over here. And those of you who have been continuing with all the videos, for you we start the class. Right, so the topic that we will be covering is the members voluntary winding up. And what have we seen in the previous classes? We have basically seen the appointment that the members voluntary winding up would start when the members they pass a resolution of voluntary winding up and they appoint the liquidator, one or more liquidator, and also decide its fees, right? And we also know that when the liquidator takes charge of the office, when they come in the position to wind up the company, the power of the board of directors that comes to an end. They cease to hold their powers, right? But yeah, they can continue it only if the liquidator says yes, you can continue, or the members they pass a resolution. Then we saw that the notice of appointment is to be given to the registrar and the ITO. And we had seen, if I talk to you in this, then we saw that there are three people sending notice to the registrar: the directors, the liquidator, and the company. When does the director send? It is when the liquidator takes charge of the office, and they have to intimate that, dude, I am not the person who is concerned with the affairs of the company now. So if you have any correspondence, anything to discuss, anything to convey, please convey it to the liquidator from now on. The liquidator will always send to the registrar in 30 days time, right? That is pervasive thing throughout the chapter. Wherever you have a concept that yes, the liquidator needs to inform the registrar, deem it that it is a period of 30 days, right? And in that 30 days, the liquidator also needs to intimate to the ITO, the income tax officer, right? And the income tax officer reverts back in 3 months, right? And then about the member, if you're talking, then the member will send an intimation to the registrar when they have appointed a liquidator, within 10 days of appointment of liquidator. And if there is a vacancy in the office of liquidator, within 10 days from the date of that vacancy arising. And again, when they have appointed a new liquidator, within 10 days from the appointment of the new liquidator, right? So these things have already been discussed in detail. Now, the other topic is that in case of insolvency, you will call the creditors meeting. Who is you? You is the liquidator. So when the company goes insolvent, the question is why does the company go insolvent? I think we were studying about the members voluntary winding up, and the directors have already given the declaration of solvency. So where does the point of insolvency come? That is when the declaration of solvency goes for a toss. Right? They had given the declaration of solvency, but ultimately that was proved wrong. Which means either the company could not pay up all the debt in the period of 3 months, or they don't have enough assets. They are in the second year, but they don't have any assets. Sorry, not 3 months, 3 years, right? They don't have any. Either they fall short of the asset or they fall short of time. In any case, the declaration of solvency stands void. Right? It was false declaration. So whatever consequences follow to the director, that is a separate issue. But now for the winding up thing, what are we going to do? You understand the trouble over there? The liquidation or the winding up did not proceed the way it had to, because the liquidator took it forward as if we have all the money, we can pay off everybody. So whoever is coming, he is getting the money. Wherever the asset is going, the asset money is coming, the money is stored. They know that, okay, we have surplus, whosoever comes, we'll give it to them. Right? But when you have shortage of money, you have to follow the priority list, the preferential payment, the overriding preferential payment, the secured, unsecured creditors, where are they being placed? All these things have to be decided. So now when the declaration of solvency goes for a toss, they'll now call the creditors. This is an alarming situation. The creditors will be called and then they will sit down for a meeting and discuss, oh, so you don't have funds. So my money is now at stake. So you want to say that you are not able to pay me the money. Okay, let's find it away. Let us call more contributories. We'll call the money, the pending shares. We'll dispose of the other assets as well. We'll dispose of everything. And then we'll pay it off an order of preference. And then the winding up, the voluntary winding up from members converts to the creditors' voluntary winding up. That is what we have seen, right? Now, call annual meeting when the winding up continues for more than a year. Obviously, in general, the winding up will continue for more than a year, because a year's time is very small for you to dispose of all the assets, make a list of the creditors, pay all of them away and everything. Like, it's a cumbersome process. Not all the assets are readily saleable in the market. Not everything can be disposed of like that. Right? So generally, the winding up proceeding will take some time. Maybe 1 year, 2 years, 3 years, 5 years, whatever it is. Right? So when 1 year has already lapsed and nothing has been concluded, right, then people are suspicious. Nobody knows what is going on in the company. When the directors are not at par, the members are not holding their meetings because they are not being called. Only the committee of inspection may be meeting. There they have the contributors and the creditors. Not more than that. So what the liquidator has to do is that he will be calling for a meeting. A general meeting, right? So for example, now the liquidation started on one particular day, and then for the next 1 year, the liquidator, he went on with the procedures, with all the processes that he had to follow, and 1 year has lapsed, but still no conclusion has been drawn, right? So now there will be a 3 month time given to him. Within that 3 months, now you need to call a general meeting, the general meeting of all the members. And this general meeting will not be called only for the first year. Even if it continues for 2 years, then 3 months from the end of that second year. For 3 years, then 3 months from the end of that third year. And it goes on as long as you take. With the lapse of every single year, you will have to call a general meeting for the period of, within the period of next 3 months from the end of that period. And then, in that general meeting, in front of those members, that liquidator will place the record of all the dealings and all the acts that he has performed. He'll place an account in front of them, right? And in that account, he'll also show the entire conduct of the winding up that he has been following, the procedure that has been followed throughout the previous year. And along with it, he will also file a statement to them, right, where they'll show the entire procedure and the entire processes that they have followed. What is the position of liquidation? Where have it been reached? If there were 100 creditors or debts that had to be paid, how much have you done? What is the percentage of liquidation that has been over? What is the prediction? By when will you be able to dispose it of? Do you think all the creditors will be paid? Do you think that no, we will not be able to complete with the winding up? What are your projections? What do you think? What have you felt? What is your plan of action? What have you done so far? All those kind of things will be placed in front of the members in the general meeting. And they will be aware of the fact, okay, this is what is going on. So this is the remaining period approximately for which we may still have to wait for the company to be wound up completely, right? So these procedures carried on for years after years, and finally one day the entire company was wound up. Right? Either it was wound up because all the debts were being paid, or it was wound up because nothing else can be done. Whatever the situation, ultimately the winding up cannot be proceeded with. That is the conclusion. Right? Then what? The next step is dissolution. Like we had seen in the compulsory winding up, when the official liquidator is not able to proceed with the winding up procedures, or is not able to proceed because the winding up has come to an end, he has done everything, then what is the next step? The next step is dissolution. And who does the dissolution? The only person who is authorized to order dissolution is the court. Yes, the High Court that we are talking about. Right? So do you think that, okay, they have done all the procedures, they go to the court, they say, court, we have done all our procedures, the company has been wounded up very well, please order dissolution. Will the court order dissolution as such? No. Because the court cannot rely on your work. So what? Will the judge come and inspect? No. Will you have the hearings? One party saying he has done, one party saying he has not done. No, nothing of that sort can happen over here. What will happen is that the official liquidator will be given the charge. Okay, the liquidator who was appointed by the company, please come, submit all your documents, all your proceedings, all your dealings, all your accounts, all your statements. Give it all of them to the official liquidator, and then the official liquidator will start scrutinizing it. We'll see what are the procedures he has followed. We'll see what are the assets he has disposed. What was the gain from that asset? Right? What was the list of creditors? Whom did he pay first? Whom did he pay last? How did he proceed with? If there is somebody who has not been paid, what is the reason? Why is he standing in the line? And why have others been paid? There's a lot of things that the official liquidator will not check. Right? So we will understand these procedures step by step in the next slide. The next slide we have is a slide for dissolution, where the liquidator prepares the final account and calls the general meeting. Right. Now, when the entire winding up has been processed, the procedure has come to an end. Now, every year the liquidator had prepared those pieces in that bets. He had prepared the statement, he had prepared the account, he had prepared the return for the procedure that he had followed throughout the year, for the assets that he had realized throughout the year, or the liability that he had paid off throughout the year, the creditors, the debts. So he will correlate all of them now. He'll combine them and prepare a final account. Right? A final account of how the winding up has been conducted and how the properties of the company has been disposed of, how the payment has been done. All these things will be consolidated and prepared in a single account. And when that is prepared, a final meeting will be called. A final meeting of the members. Right? And in that general meeting, he will lay before the final account. Okay, boss, this is what has been done. Now the entire dump is now in front of you. Please go scrutinize whatever you want to check, whatever you decide, and say that yes, we have been able to, we have winded up the company successfully, and then so that we can go to the official liquidator. But there is one thing. The directors have already ceased to hold their office. Their powers have come to an end. They must have shifted to some other company so far. How do they call the meeting? Earlier, this was the rights, or this was the task for the directors. They had to convene the meeting of the members, right? Now the liquidator is left alone. How will he call the meeting? He cannot issue the notice and send it to the registered address of all the members and follow the entire same procedures. No, that cannot be done. He doesn't have the resources, he doesn't have the addresses, he doesn't have the funds to do that. He doesn't have the time to do that. What will he do? So when he thinks that, yeah, it's time we should call the general meeting, so 1 month in advance, he will give out an advertisement in the official gazette. He'll list it out in the official gazette that yes, on this day, this place, this time, we are going to conduct a meeting for all the members of the company, because the winding up procedure has come to an end. Right? Along with the official gazette, because not everybody sees the official gazette, he will also make an advertisement in some newspapers. No concrete quantity has been given. It's just said some newspapers, maybe 1, maybe 2, whatever you want to do. Right? So he will give a declaration, he'll give an advertisement in the newspaper that is running in that district in which the registered office of the company is situated. Right? And then he will wait for 1 month, and that day arises, and on that day they will hold the general meeting. And the members will come, the members will see that account, see that statement, be satisfied and go back home, nothing else. They're not doing anything. They're just bought here so that they can be shown the entire accounts and they can be shown that yes, the the winding up has been done. If you have any objections to raise, please raise it. If there is something more to do, please tell me. Otherwise, it is over. Go back home, relax. Right? And then, 1 week from the conclusion of the general meeting, the liquidator will have to send to the registrar as well as the official liquidator a copy of the final account. Right? Because now you know the official liquidator will have to come. Because the court will rely on the official liquidator, not on the liquidator that the members have appointed or the creditors have appointed. Right? So, the general meeting was called so that he can share the account with the members of the company before giving it out to the official liquidator. Now, when the general meeting is over, within the next 1 week, he will have to send that account and that statement to the liquidator, the official liquidator, as well as the registrar of the company. Right? And over there, he'll also inform that, yeah, this was the date of holding the general meeting. So, I've already conducted the general meeting, so don't say that I have defaulted somewhere. This is the date, the members have come, and it is over. But, for example, suppose you had given an advertisement, right? That is all you could do. Given an advertisement in the official gadget, an advertisement in the newspaper, but nobody turned up. Yeah, if you're in that district, your shareholders may be throughout the country, right? Newspaper in that district will not suffice. And who reads the official gadget continuously? Nobody. Maybe nobody was aware. People didn't know, people didn't want to come. Whatever happened, the quorum could not be met. So will we say that the general meeting was validly held? No. Because if there is no quorum, we know that we cannot hold a meeting. So what? Now will he give another advertisement and wait for another 1 month and then go to the official liquidator? Again, if the quorum is not met, will he again wait for 1 month? Will this process continue forever? The Act says no. It was his task to show it to the members. If the members are not interested, if they did not see, they don't want to see, it is not his duty to go to everybody's place and show it on their face that look, this is the account. No, he's not supposed to do that. He's the liquidator. If the members did not come, then it's your loss. Still, from that very day, within the next 1 week, he can go to the official liquidator and file the account. He can go to the registrar and file the accounts. Right? So if you see on the screen, if quorum is not present, make a return. That meeting was duly called. When you are filing the return, you say that the meeting was duly called. These are the procedures. See, I have given the advertisement. Members did not turn up. There was no quorum, so it could not be held. So he is not liable, and that will be, if he had called the meeting genuinely, right? That would be a good provision of the fact. Right? So if he is able to prove it, then the registrar will go ahead and register those accounts. Okay, your accounts and everything, they have been registered. So that is final now. And once he has registered and locked it down, now is the time when official liquidator will start the scrutiny. He will start scrutinizing the accounts, all the books, all the papers of the company. Right? And as you know, if somebody gets into a scrutinization or if somebody gets into an inspection, all of the parties who are there, right, for the winding up, the contributors, the creditors, the liquidator, everybody, they will give him all the reasonable support that the official liquidator needs. If he wants to inquire about something, hey, were you actually paid? He'll say yes. Hey, did you actually bring the money? He'll say yes. Hey, did you actually take the asset? He'll say yes. Right? He can confirm from anybody. He can go and he can scrutinize the scene, whether the facts declared in the accounts are true. And based on this, the official liquidator will now prepare the final report to give it to the court. And based on his report, what will happen is, if he says everything was conducted very well, everything was in place and the report is correct to the fullest of his knowledge, and then the winding up has been completed without any fault, without any issue, and so the court, you should now give a dissolution order. Right? He'll say that the liquidation was not conducted in a manner which is prejudicial to the interest of the members or the public. Right? If that is the kind of report the official liquidator gives, then from the date of submission of that report of official liquidator, we will consider the company to have been dissolved. So anything coming after that date will not be entertained because the company has already been dissolved. The name has been struck off. It is no more a company. It's dead. But if the official liquidator provides a report otherwise, that means if the official liquidator says that no, although they have done the winding up, but the winding up procedures were followed such that it was not in the benefit or in the interest of the public or the members on the whole. So what will the court do? The court will say, oh, is that the scene? I will not allow them to dissolve now. There may be other things that they need to do. So what will the court say? Court say, okay boss, go ahead. Go ahead and scrutinize, investigate and see what has happened actually. If something is wrong, please amend it. You have been invested upon with all the powers. Right? I give you all the powers, go ahead and do it right. If it is not in the interest of the members, not in the interest of the public, make it in the interest of the members and the public. And then you come back. And then when the official liquidator goes ahead, he does all his tasks, and when he comes back, by either rectifying everything or if there is something he could not do, he will again report back to the court. And now if he comes back with a positive report that okay, I have amended everything, the court will say okay, now the court will decide that from this date the company will stand dissolved. But if there is some other thing, some issue over there, then the court will go accordingly. The court will take its decision, the court will take its discretion. If it wants to dissolve, it will dissolve the company. If it does not want to dissolve the company, wants to go ahead with some other procedures, it can do it. That is out of our winding up concepts. What we have seen is, okay, we have given it to the official liquidator. He came, investigated, he found something wrong. He came back, he investigated more, he did everything right, he went back. Now again something is wrong and that is out of the hand of the official liquidator, and let the court decide. Right? It is case specific. We cannot study all of it. Right? We don't know what all kind of cases can come up. Right? Forget about it. The only thing you need to know is the second time, whatever the court wants, it will do. Nothing. Right? That is the end. We have done the members voluntary winding up. We have completed the topic completely. Right? So if you have any issues, any query, anything to discuss, anything you want me to discuss further, any topic that I may have missed, or you may not have retained the complete clarity about it, then you can please mention it down in the comment box. I'll get back to you with it. Right? In the next lecture, we'll again start with the creditors voluntary winding up and then take away the procedures in that way. And then we'll again differentiate between the members voluntary winding up and the creditors voluntary winding up. And then moving ahead, we'll have the winding up by the supervision of the court, under the supervision of the court. Right? So that will be our schedule or the sequence of lecture ahead. So until then, please stay tuned. This is Abhinay Gupta signing off. Thank you and bye-bye.